Hey guys, it's Anthony Bandiero here, attorney and senior legal instructor for Blue Eagle Law Enforcement Training, bringing you another roadside chat, not roadside chat, but a webinar about 3 golden rules. These are basically pro tips about search and seizure. All right, this is a live audience, so if I'm looking over here and I see, if I'm reading something that's a question and so forth, I am encouraging everybody to put their agency and their state in the chat. Only a fraction of the people here have actually done that so far. So please do me a favor. It's a lot of fun. And I don't ask for much, that when you put your agency and your state, it actually shows everybody else who's here. All right. Okay. So disclaimers, laws and agency SOPs may be more restrictive. If I say something in here that conflicts with what you're doing at your agency, just let me know, that, hey, we don't do business that way, or our state has more restrictive requirements. If you have any doubts about the legality of your actions, push to the chain. In other words, sometimes you have confusions, right? You don't understand what the law is, but you have to know the law, and you're presumed to know the law. So you got to get those questions answered, ask people. And finally, this course is legal education, not legal advice. For those who are joining us on demand, who are watching a recording of this, I'm broadcasting from my hotel room in Salt Lake City. I am here as a speaker at the National Association of Field Training Officers, NAFTO, and 2024. Okay, so this is our kind of agenda, some fundamentals, golden rules, some takeaways, and here is another little thing for you guys. Unfortunately, we're not going to be here, really much more than, unfortunately, maybe fortunately, but unfortunately for many of you, we're not going to be here more than an hour. I have to attend a mixer tonight that actually Blue to Gold is sponsoring. And so I got to go there and play host for the NAFTA conference. So we're going to be here for about an hour, and then we're going to be gone. We may have trivia. We'll see how much time we have for trivia, but we're not going to have a search and seizure show afterwards. However, I did record a bunch of videos for YouTube that Teresa is getting up on the channel and for Instagram. Let's do some fundamentals. You guys know, okay? You guys know it all starts with the Fourth Amendment. It says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And no warrants shall issue but upon probable cause, supported by oath or affirmation, in particular describing the place to be searched and the persons or things to be seized. Now, what's up, Zach? Zach is here. That's awesome. So Zach Miller is one of our instructors. We did a lot of videos today for the YouTube channel. So guys, at the end of the day, these 54 words control 100% of your behavior. When you're doing a search or seizure, you know that the Fourth Amendment is in the background. But at the end of the day, the Fourth Amendment only prohibits one type of search or seizure. What type is that? What type of search or seizure is prohibited by the Fourth Amendment? That's right. That's right, Shane. Right? Unreasonable. So if you're being reasonable, you're being 100% constitutional. However, you can't just go out there and say, Your Honor, I felt I was being reasonable. That may be how you feel, but it's not what the courts are looking for in 2024. You got to articulate what you're doing, right? Now, we teach an acronym at Blue to Gold that basically defines what it means to be reasonable under the Fourth Amendment. In other words, if you are doing a search or seizure, then you have to look at this acronym. What is that acronym? Shane Crew. Good, Willie. So here's my point. If you have a consent to search something, that consent has its own requirements, but that's being reasonable. If you have a recognized exception, that is being reasonable. You want to search my car? Fine. Do you have probable cause? Do you have the motor vehicle exception in most states? But if you don't have my consent and you do not have a recognized exception by the U.S. Supreme Court, then you better have a warrant. And for that, there are no exceptions. Not really. I mean, I know people like Zach Miller, like, oh yeah, we got the inevitable discovery rule. I like to say that helps our friends in the courthouse, but doesn't help you on the street, because we don't want to violate people's rights and get our evidence in with a loophole, right? Zach, already have a bill coming your way. Already bill. So it does not stand for can't really explain why. Those days are over, right? You got to understand what you're doing out there and why. You can't just go to court and say, Your Honor, I'm sorry. I thought I did it for officer safety, but I don't know, or whatever. You got to understand the why. Give me some recognized exceptions. Okay. Put some things in the chat that you can do a search or seizure without a warrant because the courts say you can do it. Plain view, plain smell, exigency, automobile, consent, community caretaking, medical aid, a lot of plain view stuff. Absolutely, right? There's all kinds of stuff out there. There's all kinds, the protective sweep doctrine, regulatory inspections, inventories, highly regulated businesses, and so forth. These are all things, right? Tow policy. These are all things that you get to do without a warrant, even though they are searches or they are seizures. However, they have their own rules, and you have to abide by them accordingly, right? Right. No problem, Emmanuel. What's up, brother? Okay. Well, Zach, you see what Amanda said on Chondo? So Amanda, I think Kansas City recognizes Anchondo. I think Anchondo has been misunderstood. I think it's been misinterpreted. And I think if you actually knew the facts on Anchondo, I think it would be fine. But you look at our video that Zach and I did today, and I think it's very misunderstood. Very misunderstood. Okay. Golden rule number one. Now, look, guys, here's what we're doing here. Okay. I gotta make sure that I don't yell too much and my neighbors, in the next room at the Motel 6 start pounding on my door. Right. But I just need you to understand what we're talking about today is how to make good case law. Right. How to get the court on your side. And let's start with golden rule number one. Right. So, Zach, I didn't know that. And Anderson. Okay. So I got to read that case. But what did they like about it? What was the option? Like, what was the alternative? To do what? Just arrest them first and then do a search into arrest? Let them go. Oh. Okay. They said there was no PC. Interesting. They couldn't pronounce his name. I did not know that. Amanda, I'm so glad you brought that up. I did not know that. All right. So the more you articulate why you did something, the more likely it will be upheld in court. That is absolutely true, right, guys? Let me ask you something. Do you think that most cops do the right thing, even though they don't know why? Right? Right? Don't you think they do the right thing? Sometimes their intuition, right? But they got to articulate, though, right? I would like to say, like, the days of hand holding the cops are over, right? We got to get it right, but we also have to articulate why. And I just saw that Mike Boone, the amazing Mike Boone, has entered the building. What's up, Mike? Rick, we might have to do a quick threesome here. I'm sorry. In my brain, I was like, should I not say that? I'm going to say it. We should do a threesome here and get Zach, Mike, and me on the camera. Hey, Mike, are you able? If you're able, are you able to jump on the mic or the camera after this webinar? Yes or no? If you're not, I understand. Oh, you're driving. Even better. Well, you got an hour. Okay. Yeah, exactly. Get the band together. So this case right here. So first of all, I have a saying, right? Just like a joke here. Ye who articulates the most wins, right? And you got to articulate, right? That's what Shakespeare said. He didn't say it, but I know that he would. Officers received information that the vehicle listed above had been located at South Durango, and officers were dispatched to that location to recover the vehicle. While officers were on scene awaiting a tow truck to recover the vehicle, A white male came out of the apartment complex and got into the driver's seat of the vehicle. The male was later identified as Giovanni and was taken to custody without an incident. He was read Miranda, to which he responded, I don't want to talk. Since he was in possession of a key of the vehicle and got into the confirmed stolen vehicle in the officer's presence, due to those facts, he was arrested for possession of a stolen vehicle. Now, actually, this is not the Molina case. That's a unfortunate miscite. But is this enough articulation for possessing a stolen vehicle? Yes or no? Is this enough articulation? Yes or no? Okay. Sean says no. Okay. And Michael Brave says no. So the answer is no, because it's missing this, right? It's missing knowledge, right? You know, it barely, if it has probable cause, it's barely probable cause. I think I could argue that there's no probable cause there because he's acting like an innocent person. He has a key to the car, but the cops had more information. The car was stolen with the key, and so forth, right? So there could be more things there that you could put in a report. Even suspects know that when you write crappy reports, they're going to walk. A woman was arrested for soliciting prostitution at the Cosmopolitan in Las Vegas. After she was arrested, she told the officer this. She says, I'm going for loitering for prostitution, right? It's going to be dropped because you guys write weak-ass reports. So I don't care. I'll be out in less than 2 hours. So that's pretty bad when even your suspects are calling you out for your crappy reports. You got to write better, okay? And again, this Molina case is a I gotta, Rick, do me a favor, remind me to take the Molina case off here because it's an artifact that should have been taken off when I did these slides. The above-mentioned officer observed 4 white male adults walking from the west side of Main Street to the east side of Main Street. The 4 males were observed crossing the street outside a clearly marked crosswalk. Officers conducted a person stop on all 4 subjects. So we're talking about like a jaywalking case here. I contacted one of the male subjects, who was later identified by his Nevada identification card as whatever, who was wearing a white and black, he was wearing this and that. The suspect was also wearing a lime green cross body bag across his chest. So what are we thinking here? We're thinking that he has a gun. That's what these officers are probably thinking. I asked the suspect if he had any weapons on him, which he informed me that he had his friends. At that point, the suspect was placed under arrest for carrying a concealed weapon without a permit. Okay, you guys can probably see the problem here, right? There is no evidence here that he was an illegal or prohibited person, that he had no concealed carry permit, nothing. It's not a good case. It's not articulated. And the case is going to be dead on arrival. Okay, so Chad, real quick, he says, hey, when running a license plate in California and the DMV returns shows the registration is suspended, not expired, can we use that as probable cause to stop the vehicle? The answer is yes. It violates VC 4000 what .38, Zach? What is that? 4000.38 or something like that. It's a vehicle code violation. So if you can cite it, you can stop it. So there, we Zach and I talked about that today, and we cannot find a reason why you could not stop it. 4008. Thank you. You're welcome. What type of weapons recovered? How do we know that he didn't have a permit and so forth, right? Okay. Now, 2 recommendations for articulation: the rule of 5 and articulate conclusions. Strive to articulate at least 5 facts or circumstances for a particular search, seizure, or crime. Guys, this is arbitrary, and we understand it, but this comes from our report writing class. At Blue to Gold, we are all about articulation, right? I'm not going to try to be rude here, but guys can do a better job with this articulation. A lot of times, you're doing the bare minimum, okay? You're doing the bare minimum. So please articulate more, right? This whole thing of kind of like strive for 5. It is arbitrary to some degree, right? Maybe sometimes you'll need 10. Maybe sometimes you need 1 factor. But generally speaking, you probably need more than 2 or 3 on average, right? You can do better. I get why not 5, why not 4, why not 6. I understand that it's a little arbitrary, but you need to do better, okay? I mean, overall, as a profession, we need to do better. Let's look at this case, U.S. versus Morales. Did the officer have reasonable suspicion for narcotics trafficking, right? That's a question for the court. And the court said that The court held that reasonable suspicion existed for these reasons. Number one, the driver gave internally inconsistent answers about travel plans. Inconsistent answers about how he knew the passenger beyond a first name. That's kind of odd that you don't know people's last names when you're driving the same car. Admitted to recent border crossings. Admitted to drug-related prison sentence for 116 kilos of marijuana. Extreme nervous, neck pumping, and heavy breathing. That is reasonable suspicion. The other thing that we want you to look at is articulate conclusions, right? So state your opinion and then state the word because. The word because is the most powerful word, right, in a police report. A lot of things that you say can be fixed when you articulate why, right? Why are you doing this, right? But don't use the word because like this. During the Arizona versus Gant case, the officer was asked why he searched Gant's car after arresting him for no license and a warrant. His response, because the law says we can do it. That is a very shitty way of articulation, okay? And I'm not saying that the cop would have won the case if he did better here, but it's still something that we are concerned about, right? An officer wrote that his blood draw was consensual. It's a key issue because there was evidence that maybe this wasn't consent, right? That's why the DA is asking, but provided no reason why. When the DA asked for a supplemental, he said this: based upon the arrest report and detailed search of the documents associated with this arrest, there is no information to support the blood draw was not consensual. Look, the defendant has no burden, right? They don't have to prove anything. We have to prove it. If the argument is that, oh, how do you know that blood draw was consensual? We have to prove it, right? We have to prove it, not them. So let's rewrite this. How about this? The blood draw was consensual because, and this is 4 things, not 5, but still it works. I read him implied consent. He told me he understood it. He told me he would submit to a blood draw. When the blood draw was taken, he cooperated with medical staff and did not refuse, resist, or complain. That is articulation, right? That is consent. And that's what we need to have here. As I spoke with the suspect, I observed obvious injuries to his face and a bleeding laceration on his left thumb. It's not obvious unless you're going to put a picture of that in the report. As I spoke with the suspect, I observed obvious injuries because the suspect was non-compliant. That is an opinion with no facts, right? The suspect was non-compliant because he said, I'm not going to jail, ignored commands. The stop was made in a high crime area. That's old school writing right there. Maybe your forefathers got away with that or officers with 20 plus years on, but not today, right? The area where I stopped the suspect was dangerous because the victim was hysterical, right? This is going to be very important in some of your cases. There's an excited utterance doctrine out there that would depend on the person's stress of the moment, right? And so when you're investigating domestic violence and you're and talking to victims and they're accusing other people of committing, crimes on them and so forth, sometimes their demeanor is important for our discussion. Okay, the victim was hysterical because she kept waving her arms around and so forth. I searched the vehicle for weapons for officer safety. That's an opinion. Let's do a little better than that, right? I believe the driver was armed and dangerous because the driver was extremely slow to stop. Immediately challenged my authority to make the stop. Closely watched my actions upon approach. Constantly pleaded to be let go with a warning. Had a nervous tone in his voice. Was convicted of robbery in 2019. That, my friends, is much, much better. And one of the funniest cases, this idea of using the word because, is here. This lady was arrested for prostitution in Las Vegas. And the cop said, and I quote, I escorted Teresa down to a security room and interviewed her. Immediately apparent to me was her level of intoxication, and the smear of lipstick on her face suggested that she had very recently engaged in some form of oral copulation based on my experience. I don't think it gets any better than that as far as articulation, okay? So, I mean, you might have to get this cop's wife to testify as an expert witness, so we have that, but regardless, it is a very funny case. You don't want to rewrite that one. That one is perfect. Let the cop explain what he means based on his experience. William says, sorry, Melda. All right. Just fine. So we did a lot of videos on this, actually. We answered a lot of these questions on YouTube, and they're coming up. So keep an eye out on the YouTube channel. It's all coming out. Hey, Rick, can you put a link to the YouTube channel? Or Teresa actually has it too. So those videos are coming out. Let's do golden rule number 2. Okay. This is the more serious the crime, the more reasonable your actions are likely to be viewed. Guys, this is absolutely true. Okay. Absolutely true. The Fourth Amendment is restrictive. Okay. It restricts you. Okay. It doesn't say do whatever it takes to fight crime. It does not say that. However, it is rational. It really tries to get the appropriate balance of crime control and freedom, right? And I got to tell you, like, that's how we want it here. That's how we want it. We don't want, I don't want to give you all the tools necessary to fight every single crime, okay? That is called a dictatorship, okay? That is not going to work for me. I actually need some restrictions on you because I don't want cops in my house without a warrant just to look around and make sure that I'm not violating any laws, right? But at the same time, right, though it's restrictive, it is rational. So the court is going to understand that when you're dealing with serious business and serious issues, you get to do more serious things. As the court has said, an important factor to be considered when determining whether any agency exists is the gravity of the underlying offense for which the arrest is being made. Now, this is an arrest case, but the point is, what is the severity of the situation? If cops are dealing with shots fired and domestic violence, calls and, medical emergencies, you get to do a little bit more intrusion than you're dealing with a dog barking call or, a petty larceny and so forth, right? Here's an example. So neither the use of handcuffs nor the drawing of a weapon necessarily transforms a valid Terry stop into a de facto arrest. So a Terry stop is that investigative detention, right, where you're allowed to diligently confirm and dispel your suspicions. But a de facto arrest is when you went overboard, right? When the use of force usually was so high that a reasonable person would believe they've been formally arrested. So let's talk about this case. I think it's called Torres. Now, here's where it happened. So this is where it happened. And what happened here is an officer got flagged down, okay? And this person, so the officer got flagged down, and the reporting party, the citizen, said, hey, there's a guy on the bridge. And moments before you arrived, he was shooting a gun into the building to the left, okay? So the cop was like, all right. So the officer, has this call, this citizen reporting, goes down there, sees this guy walk on the bridge, minding his own business. He gets out and he points his gun at him. Get on the ground. Show me your hands. Get on the ground. He then pats him down and he finds his firearm. Torres was like, whoa, 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 right? That wasn't justified. You can't point your gun at me. That was a de facto arrest. Based on these limited facts, were the cops okay pointing the gun, yes or no? Okay. Jeff, Jamar. Okay. The answer is yes, right? As the court held, to begin, there is no per se rule that pointing guns at people or handcuffing them constitutes an arrest. Terry recognized that when officers are investigating a suspect who the officers reasonably believe is armed and presently dangerous to the officers or to others, it would be clearly unreasonable to deny the officers the power to take necessary measures to determine whether the person is in fact carrying a weapon and to neutralize the threat of physical harm. So it just makes sense. The officers did the right thing here. Versus this, okay? Actually, let me adjust something real quick. Okay. Police saw an apparently wealthy driver stop and exchange something, maybe drugs, right, with a homeless person in a high crime area. Driver was polite, not nervous, consented to a search of his person and car, but did not have his license. Instead, provided credit cards and Costco card with his picture. Cops placed him in handcuffs while running him. Now, do you see what's kind of going on here? The question is, were those handcuffs appropriate? And there are a lot of cops out there that put people in handcuffs just because they don't produce a license. I don't know, Zach and Mike, if you've seen that before, but I have, right? They'll get the person on the hand, other car and just boom, put them in handcuffs. No, right? Right, exactly. Handcuffing is the exception, right? And was handcuffs justified? And the answer is no. Both officers would later testify that if a driver lacked identification during a traffic stop, listen to the words. It was a standard practice. The officers would handcuff the driver because the officers had fair notice that they could not handcuff the driver without objective safety concern. We conclude that the district court erred in granting qualified immunity. Okay, so these cops are not getting qualified immunity, and they shouldn't because they don't know the law, right? They don't just put people in handcuffs just because they don't have their freaking ID on them. Now, he did the drug issue, However, just so you know, in that case, other officers came there like to back him up and like they're shooing these cops away, we're code 4 and so forth. And the court did not believe that these guys were in any safety concern because they were like no backup. They didn't, anyway, you get my point. So we got to be careful here. Example 2. Police warrantlessly entered a home because the neighbor said he was unable to get a hold of an occupant. Mail and trash piling up. Neighbor was emergency contact. And occupant's doctor could also not get a hold of the occupant. Was there agency to enter the home? And Mike Boone, please resend that to everyone who went to host and analyst or panelists, right? The answer is yes, right? Was the entry justified? Under emergency aid, exactly, Sean, right? Lawful entry under emergency aid versus this. Caller reported that a child was being abused in a car, like a corporal punishment, right? Police ran the license plate and went to the address. The car was not present. And after receiving no answer, the police turned the door handle and opened the door and saw plain view evidence. Was that lawful under the emergency aid exception, right? And Tim and so forth and say no, right? What's up, Angela? Willie's like tossed. No, right? There's no agency here, especially with the card not even being there. And we have to know what kind of abuse we're talking about, right? And Michael says there's not much you can say after standard practice that would be reasonable. Example number 3. Okay, let's talk about hardiness, or as I used to call it, Jardines. But let's see what happened here. So here's what happened. I actually need a picture in here, but here's what happened. So Miami police had intel that Hardiness was growing marijuana for sale, right? In his house right there in the picture. And they, are going to do a knock and talk. So they bring Frankie, the drug sniffing dog, with them, on the knock and talk. And that actually is a picture of Frankie, the dog that was actually used in this case. And if you know your case law, that's pretty cool, right? I mean, that's really neat. And I also saw him and I figured he's a Miami police dog, and that's why he has like that white powder on his nose. So while during the knock and talk, the dog is brought during, at the front door, while on Hardinus's curtilage. And predictably, the dog does what? It alerts. Now, they use that alert in a search warrant. And the question for the court is, are we good? Can we bring that drug dog to the house on the curtilage and sniff that guy's door, right? Tim, that only went to host, please. Where you send it? And say Amanda as well, Amanda Ray. Chris Rogers. So guys, I see a lot of people, do me a favor, fix your chat settings so they say it to everyone. So we want to make sure we see your comments. And the answer is no, right? As the court said, to find a visitor knocking on the door is routine, even if sometimes unwelcome. To spot that same visitor exploring the front path with a metal detector, or marching his bloodhound into the garden before saying hello and asking permission would inspire most of us to, well, call the police, right? Versus this. So the drug canine versus this, right? Do you like this? Do you see what's kind of going on here? By the way, Rick, what do you think about this little animation? I think it's kind of cool. One cop versus another, right? One case versus another case. What if the cops had reasonable suspicion illegal explosives were inside the home and they brought an explosives canine? What do you guys think about this? What if they had, I don't know, a hunch, reasonable suspicion that there might have been, somebody said that the guy's making pipe bombs and he brought the explosive dog. What do you guys think about that? Mm-hmm. Okay. There is a good chance, right? There's a good chance. Joseph, change your settings to everyone. It's only went to me. So the U.S. Supreme Court, I'm sorry, a case in Lewis, not the U.S. Supreme Court, but a case in United States versus Lewis, they said this case involves a dog sniff for controlled substances, not explosives. Even the dissenters in Caballos recognize that a dog sniff for explosives involving security interests not presented here would be an entirely different matter. Now, this case does not give us the answer, okay? It simply tells us that that golden rule number 2 is in play, right, Shane? The more serious the crime, the more reasonable your actions are likely to be viewed. There is a fundamental difference in making pipe bombs in a neighborhood and growing marijuana, right? Fundamentally different. All right. Golden rule number 3. So where are we at right now? Let's recap. Golden rule number 1 is the more you articulate, the more reasonable your actions like to be viewed. Golden rule number 2 is the more serious the crime, the more reasonable your actions like to be viewed. And finally, golden rule number 3. Donald says, how about a canine sniff on a mini warehouse for stored marijuana? Good to go, right? As long as it's not curtilage. And it's also not in what state? What state did not allow sniffs of storage units? Zach, which one was that? That was no, it's not California. It's Minnesota. It is Minnesota. Yes, yes, yes. Nice. It's Minnesota. You could not do that in Minnesota because in Minnesota, they're not searches, but they still need to be justified with reasonable suspicion. So the answer would be no in Minnesota, but yes, pretty much everywhere else. All right. Golden rule number 3. The court is concerned with probabilities, not possibilities, right? Now, I want to let you guys know that, Amanda, do you see a change here? Do you see that this is not the same golden rule? So here's the deal, okay? I got to tell you that the old golden rule before this webinar was conduct all warrantless searches and seizures in the same manner as if you had a warrant. It's never been a great golden rule, because it's so, I'm not sure how helpful it is, number one, but it's helpful to some degree, especially with car searches. But you just don't get a lot of warrants for things, right? But here's the issue. The issue that the actual bigger issue that we're having in law enforcement is that cops love, LOVE, they love to give possibilities about stuff, right? You guys know what I'm talking about? Like, you hear it all the time. Well, it's possible he had a gun. It's possible there's somebody in the trunk. All this kind of stuff. And the courts are not real receptive to possibilities. They're receptive to probabilities, right? And as the McCall case said, exactly, I tell people it's possible. Yeah. Is it possible, Shane, that I, have a kilo of cocaine right now in my possession? Absolutely. Is it possible that there's a dead person in the back of, in my trunk? Absolutely. It's just not probable, right? I think she got out. So as the court said, thus We strongly disapproved of police conducting protective sweeps as a standard operating procedure, calling it a patently unconstitutional practice, right? Yeah. Yep. Uh, exactly. So this is, I'm glad that so Amanda, do I get your seal of approval also changing this rule? Do you think this actually helps cops a little bit more? Because they do it all the time, right? I think we can agree they do it all the time. They do this possibility, not probability, right? So look, it's like rolling dice, man. Is it possible you're going to roll the sevens? It's just not probable, right? Well, it's probable to some degree, right? But how much degree, right? Well, this is kind of how we look at it, right? I mean, hunches are like very, you know, yeah, actually, that's good. Okay. Okay. I can probably get that sent to people. So give me a second, Mike. Okay. So hunches, I mean, there's a certain level of probability, but it's so low that courts don't recognize it, right? What's our first probability? Reasonable suspicion. Mike, what is the probability of reasonable suspicion based on your research? Actually, hold on. I got it right here. You sent it to me right here. I got it. Okay. So I got it. So it doesn't really, it's just below 50%. Now, I will tell you that some of the research I've seen out there too puts reasonable suspicion about 20 to 30%. Okay, or about that, around that. What's the percentage of probable cause? Well, we know that it's less than 50%, right? So 50 to 40% ish, you can't put numbers on all this, okay? You can't put numbers on all this legally. Actually, there's only one. The only one that we can put legal a percentage on is the next one, which is, where is it actually? Shit, it's missing. Shit, I got to fix this, Rick. I wish you can preponderance of the evidence. So preponderance of the evidence, POE, is missing. If you can help me remember that, Rick, I got to fix that. So that's the only one that actually has the 50 plus one rule, right? Now, William was taught 51%. Very, very common. Very, very common. But technically, it's actually not 51%. Probable cause can be less. It's just a fair probability. Sometimes that's less than 50%. Clear and convincing evidence is in here. Mike Brave has it at 75 to 85%. Clear and convincing evidence is beyond a reasonable doubt light. Okay, it's damn close, and it's not used for many things in it's used for sometimes consent searches and so forth, but states differ. Finally, beyond a reasonable doubt, that is 95 to 99%. That's actually pretty damn high. And then the next one is right, exactly. And the next one is absolute certainty. Okay. The fact that the officers had conducted numerous protective sweeps on prior occasions as a matter of standard procedure did not justify sweep in the present situation, as officer testified that they had been unfamiliar with the defendant prior to their surveillance of his residence. Officers were unaware of whether the defendant had any accomplices, and officers' investigation revealed no persons living at the residence who may have been armed or involved in the drug trade. So what do we have here, right? We have a possibility, not a probability. Now, protective sweeps, the level of probability that you need is reasonable suspicion, right? That somebody's in the house that can be a danger. But here, we even have less than that. We have a hunch. Officers search of pockets of jacket belonging to passenger motor vehicle, which was left on the floorboard of the back seat following valid traffic stop, was justified by the protective sweep exception to the Fourth Amendment's warrant requirement. Although both driver and passenger had been removed from the vehicle when the jacket was searched, officers observed both the passenger and the driver moving within their seats, apparently in response to the presence of police. Officers observed the passenger removing his jacket at the time of the stop, creating a reasonable suspicion that the passenger was concealing a weapon, and passenger was not under arrest at the time the jacket was searched. So it was reasonably likely that the passenger would return to the vehicle and have access to any weapons inside. So, guys, that is a probability, not a possibility, at the reasonable suspicion level. Search of hotel room in which defendant was arrested did not exceed the scope of a lawful protective sweep. Search was quick and limited, spanning about 2 minutes and covering only those places in which the person might be hiding, including under the mattress. A reasonably prudent officer could have not have formed belief that the hotel room, following arrest outside of room of one of the room's occupants and following flight of a second occupant, harbored a dangerous individual, and thus a warrantless protective sweep of the room could not be justified on such grounds. Only indication that a third person could have been in the room was a lack of information about a person named in an anonymous call about suspected illegal drug activity occurring in the room, and the hotel manager's lack of information about how many people were in the room. But there was no report of noise from the room after the two occupants had come into the hallway, and there was no suggestion of any activity in a room while police were in pursuit of the two occupants. So that is a good example of a possibility, not a probability. Evidence suppressed. Officers were justified in performing warrantless protective sweep when they accompanied murder suspect's mother into the home after it had been seized, based on a reasonable fear that someone might be in the residence who posed a threat to officers. Suspect was detained outside her residence. Officers could not see into the suspect's home. Witness who reported seeing victim's dead body in home described multiple guns in the suspect's home. Suspect admitted that the victim had been shot on her property and she failed to call the police. It was reasonable for officers to fear the suspect had contacted someone else to help clean up evidence after the witness declined to help. And the hour between the witness making the report to police and officers arriving at the scene provided time for someone else to arrive at the house. That is a probability, not a possibility. State Gun Task Force officers' warrantless entry into the defendant's home to briefly search it after they detained the defendant to investigate smell of raw and burnt marijuana emanating from the home was not a protective sweep, as would justify such entry. As a precautionary measure without probable cause or reasonable suspicion, search was not incident to any arrest, nor did officers have a right to arrest based solely on marijuana smell. That's a possibility, not a probability. So let's go through a few more examples. Cops conducted a protective sweep in anticipation for a search warrant. During the sweep, the police officer looked in trash cans and a shoebox. Unless this house involves gnomes, and not just any kind of gnomes, garden gnomes. Unless this house involves garden gnomes, we are not looking in shoeboxes and probably not trash cans. Now, guys, I know cops, and cops will tell me, Anthony, that trash can, it's kind of big. People can fit in it. Hey, look, man. If you want to play the trash can game and you want to go to court and say I searched the trash can, because people could be in there, you do you, right? But it sounds like a possibility, not a probability, right? Unless you saw like the trash can moving or something else, I don't know, or it's a really big trash can. Okay, was it probable that people hide in the trash can or shoebox? No. Okay. Yeah, you better articulate the crap. I like, so Williams did he did a pun. You better articulate the crap out of the trash can. Get it? All right, I like it. Violate the Fourth Amendment. Versus, okay. Officers were lawfully inside a trailer and had reasonable suspicion there was a dangerous person inside. They also saw bulletproof vests in plain view. They lifted up a mattress box spring and saw two sawed-off shotguns and a rifle. Do you think that it's probable to reasonable suspicion level that maybe it was somebody who's hiding under the box spring? Yes or no? Box springs are hollowed out, right? They don't have cushion inside, no springs. Okay. The court found that this was lawful under the Fourth Amendment, right? The defendant attempts to cut at the officer's suspicion by arguing sheer improbability that an adult male could hide in a hollowed-out mattress without so much as a rise or bulge in the mattress. In support of his proposition, the defendant directs the court's attention to cases where we had held looking under the mattress was unlawful. Well, mattress might be one thing, right? Box spring is another. It is true that these cases help protect the sweeps over abroad, where officers search under mattresses without justification. But unfortunately, the defendant fails to take into account that it was logical under the specific facts of this case. This way, the person might be hiding in a hollowed out box spring. That's the key, right? Box springs are hollow, generally speaking, not like a mattress. Example number 2. Officers smelled burnt marijuana in the passenger compartment and searched the trunk. So it's a smoking and driving case, right? Was it probable evidence of the smoking while driving was in the trunk? Guys, I mean, if you're being honest here and like looking at it from a legal point of view, right? Is tilting and adjusting the trash can a search? Yes, if you're seeking information. That violate the Fourth Amendment, right? Versus this. Officer smelled raw marijuana, and when only a small amount was found in the passenger compartment, search the trunk. Now, I should put in here the adjective. This was like a lot of marijuana, just not it was like an overwhelming smell of marijuana, right? Now, can we search the trunk? Of course, the answer is yes, right? Lawful search of the Fourth Amendment. Okay, let's do some takeaways. Remember, you got to articulate what you're doing out there. Consider the gravity of, act as if we had a warrant. Damn it. Rick, you better write that one down too. I don't have anything to write down with. I don't want to lose my my momentum here, but that is the old golden rule. I got to update that as well. All right. But the last one, of course, is you work in a world of probabilities, not possibilities. All right. My question before we do a little trivia is, did you find this information useful? Right? Good, good, good. I love these webinars. I'm glad you guys are here. For my people that are, I'm gonna hold off on a second. Yeah, thanks, Rick. I appreciate it. I just got your email, Rick. So for those people who are here, do me a favor. If you have never left us a Google review, will you leave me one real quick? Can I just take like a 1 minute break and you just leave me a quick Google review? Man, it means so much to me and my company to make sure that we're trying to reach as many people as possible.